Welcome to the fourth module of this course. In this module, we shall go through the critical obligations of the data fiduciary. The persons who shall be managing the data of the individuals, be it companies, corporates or individuals, have the significant burden under this legislation of meeting a variety of requirements. They will have to invest time, effort and resources to ensure they are compliant with this legislation. So, this module becomes the single biggest key module for the corporates who shall be managing the personal data of individuals. A quick recollection of the data fiduciary. Data fiduciary can be any person in any individual company, firm or a corporate who alone or in conjunction with somebody determines why the data is being collected and what is the means of the processing it. That person becomes the data fiduciary. It can be a bank who is collecting information for creating a bank account. It can be a restaurant which is collecting my personal information for making a reservation. It can be any of those n number of online sites where I register my information for procuring the goods and services. All these people, irrespective of the structure of their entity, if they are collecting and managing my data or an individual data, they become the data fiduciary. And data fiduciary will also be responsible under this legislation for all the activities of the data processor. So, the data processor can be somebody who is just hired by the data fiduciary. Say a simple example that the bank has collected the information from me as data fiduciary, but it employs a data processor for sending SMS, alerts or any other information to the individual. So, such data processor is working on behalf of the data fiduciary, and therefore, the data fiduciary will also be responsible for the activities of the data processor. The first and the primary responsibility of the data fiduciary or the obligation of the data fiduciary is to process the data only for lawful purpose. The data cannot be misused. Anything which is not expressly forbidden by the law will be a lawful purpose, and only for that purpose the data fiduciary can use the personal data of individuals. The second most important obligation is obtaining the consent of the individuals before processing the data. For obtaining the consent, there will be a prescribed way in which it has to be obtained. The data fiduciary has to send a notice. Either it can be a separate document in an electronic format, or it can form the part of the set where the information is getting collected from the data principals, but a notice should be provided to the data principal for obtaining the consent. Only after obtaining a consent can the data be processed by the data fiduciary. So, the companies and corporates have to develop systems and formats and documents to ensure that the approval from the data principal is collected through issue of a proper notice. The consent that is obtained from the data principal can be of two types. One is an explicit consent and other one is a deemed consent. When an explicit consent is provided by the data principal, that consent should be freely given without any force or coercion. That should be very specific. It cannot be ambiguous as to for which purpose the consent is being given. So, the data principal has to be transparently informed about the aspect of collection of data and for what purpose it is collected, why it is being used and all that. And based on such specific information, the data principal will give a consent to the data fiduciary for processing that data. While the data principal can give a consent for processing of the data, he also has the right to withdraw such consent, right? And whenever he withdraws such consent, the consequences of such consent withdrawal has to be borne by the data principal and not by the data fiduciary. For example, the data principal has entered an agreement with a company for provision of certain services. At a later point in time, the data principal decides that he is going to withdraw his consent. He no more wants his personal data to be processed by that company, and he applies for withdrawal of that consent. and once the consent is withdrawn by the data principal, the data fiduciary or the company which is providing the service can refuse to provide any services to the data principal, and therefore the consequences of now the services getting stopped is on the data principal himself, but he has a right to withdraw the consent. And whenever the data is getting shared between multiple parties and there is a withdrawal of the consent by the data principal, it is the obligation of the data fiduciary to ensure that the data processor also stops any further processing of activity. For example, I have opened a bank account, I have given the information to the bank as a data fiduciary, the bank has passed on that information to say party C for processing of that information, that any regular alerts and any information, new products, everything that would be sent to the customer, that is handled by the data processor C. I am A individual, the bank is B the data fiduciary, and C is the data processor. In the event where I withdraw my consent to the bank stating that I don't want the account or I don't want you to be processing my data, it is the duty and obligation of the data principal to ensure that such processing is also stopped by C and C does not take any further activity. So, once the consent is withdrawn, it is the data fiduciary's duty to stop itself from any further processing, but also it has to make all the data processors with which it has connected and share the data, they also stop the processing of the data. Right. So, the consent where it is given explicitly has to be free, specific and unambiguous, and where the data principal have a right to give consent, he also has a right to withdraw it, and when such withdrawal happens, it is the obligation of the data fiduciary to ensure that they are obligated to meet the request of that withdrawal, stop those activities, and also ensure that the data processor stop those activities. The previous slide was about the explicit consent that would be provided by the data principal and what are the obligations in relation to that for the data fiduciary. In this slide, we will go through the deemed consent that would be obtained or would have been presumed to be obtained for the purpose of processing of data. In every context, an explicit consent of the data principal would not be possible, and therefore the legislation has carved out certain situation where the consent of the individual is deemed to have been obtained for the purpose of processing. One such instance is where the data principal voluntarily shares his data with the data fiduciary. For example, if I am trying to make a reservation for at the restaurant, and I go through one of these online apps or I directly call up the restaurant, I will be providing my say email ID and mobile number for the purpose of reservation. One is that they have to confirm back to me about the reservation being made, or they might be needing my number to give me a call at a later time if required. In such a case, the data fiduciary, the person who is receiving the data, would not be sending any explicit notice to obtain the consent. My act of providing them the information at the time of reservation will also be deemed to be the consent that has been provided to them for processing of the data, and any separate notice and confirmation is not required. It will also be considered as a deemed consent in case of say emergency or a medical requirement. So, if I am unwell or if I am caught up in some accident or any other health emergencies which happen, so the hospital which takes care of me can go through my medical records and the details in order to give me a treatment in case of a medical emergency. So, there the explicit consent of the individual may not be required if I am not in a state to provide such confirmation to the hospital to meet the emergency requirement. Deemed consent is also assumed in case of any compliance with required to any judgment or taking any safety measures in relation to that individuals. Further, the corporates also get certain exemptions in case of handling the personal data of the employees. So, the corporate which possesses personal data of employees can use that data for a variety of reasons, including to stop any, say, corporate espionage, or to maintain the confidentiality of trade secrets or intellectual property. Or a company can have a variety of classified information which it has to safeguard, or it can be using the data in terms of recruitment of employees, processing of salaries, bonuses, or termination of employment. So a variety of activities are taking place inside a company in relation to the data of an employee. So in the context of an employee and employee relationship, certain leeway has been provided to the company. So for processing of all this data for recruitment, termination, for maintaining other confidentiality information and all that, there is no specific consent that is required by the employer from the employee. Right now it is broadly defined to include a variety of activities. As the legislation progresses, we need to see whether some portion of it will be deemed consent and some portion an explicit consent will be required from the employee. As it stands today, the employer has a leeway to process the data through the deemed consent. And anything that the government has to do in terms of the public interest, they need not specifically ask and check with the people and the data principal whether they can process it. They will go ahead and process it under the basis of deemed consent. And for any fair and reasonable purpose, this is a residual clause which gives wide power specifically for the governments and regulatory authorities to process the data without obtaining any specific or deemed consent from the individuals. The data principal can also appoint any third person as a consent manager, and through that consent manager it can communicate with the data fiduciary to manage, review and withdraw the consent. It is not very clear in what context they will be using or how this will shape up. So as the legislation progresses and implementation progresses, we need to understand who exactly would be a consent manager and how he would take the role of a data principal in terms of communicating with the data fiduciary in relation to the data that is being processed by the data fiduciary. So last two slides, what we have seen is consent is critical and important. The data fiduciary has to obtain either an explicit consent, and in some context he will have a deemed consent that is possible, but largely for regular companies who are dealing with customers to sell services and goods, they will have to go through the explicit consent processes. The other key obligations of the data fiduciary: data should be handling accurate and complete information. So he should put all reasonable efforts to have systems and processes to ensure that the data of the individuals that is processing is accurate and complete, and no inaccurate data or incomplete data is being processed. So the data fiduciary should also have systems in place to ensure that all aspects of the legislations are taken care of, right from the systems to collect and manage the data, to appointing a grievance officer, to have time, resources to meet the requests of the people. So the entire system has to be set up by the data fiduciary in order to meet the obligations. So he also needs to bring in all those technical and organization measures to ensure effective compliance with the legislation. He has to put in the technical safeguards to protect the personal data. There should be no data breach, data leakage or other kind of stuff happening. And with the advent of the technology, advancement of the technology, there is more and more critical requirement that the companies put in the right and proper technical systems to ensure the safety of the data. And in the event of any data breach, they should voluntarily notify both the data principal and also the board on what is the breach that has been caused in relation to the data of the principal. The data fiduciary is also obligated to ensure that no personal data is retained which is no longer required for the purpose it has, and it needs to have a data protection officer. Not everybody needs to have a data protection officer. The significant data fiduciaries who handle a lot of voluminous data and a breach can cause severe implications, those companies and corporates would be required to have a data protection officer. So they should have a team of people and a data protection officer to manage the aspects of this legislation, and have an effective grievance redressal cell to address the issues of the individuals. So, the data fiduciary is loaded with a variety of responsibilities under this legislation, and even his interaction with the data processor, he cannot appoint any and every kind of data processor. Whenever he involves a data processor, that has to be managed only under a valid contract or an agreement. So, data principal would also be, data fiduciary will also be required to have proper written contracts with the data processor for sharing of the data and processing of the data. So, they have to take care of the technical aspect, they have to take care of the legal aspect, they have to take care of the processes, and they should have adequate resources to manage the requirement under this legislation. The data fiduciary has to be extra cautious when he is processing the personal data of the children without obtaining the parental consent. No personal data of the children can be processed. No process can be undertaken where such processing causes any harm to the children, and no tracking of behavioral stuff can take place so that the children can be targeted for advertising. So, extra caution and precaution is required for processing of data related to children. Some exception seems to be have carved out in terms of the obtaining of the parental consent and whether they can be targeted for advertising. It is still not clear what kind of exceptions has been created, but the provisions contain that the government has prescribed, can prescribe certain exceptions. But as the legislation stands today, any child who has not completed 18 years of age or who is below 18 years of age, when it comes to processing of data of such a child, the consent of the parent is required. No harm can be caused and no marketing can be done on the data that is processed. If you end up being a very big data fiduciary who is handling enormous amount of data of individuals which are sensitive and personal data and can cause significant risk to the society and the public order and all that, the government can notify you as a significant data fiduciary. You will have a special status of a significant data fiduciary, but you will also have a significant obligations coming being a significant data fiduciary. So, one of the primary requirement of a significant data fiduciary is that you will have to compulsorily appoint a data protection officer, and the data protection officer will be someone who will be responsible for the board of directors, and he shall be the single point of contact for the grievance redressal mechanism. Not only the significant data fiduciaries need to appoint a data protection officer, but also an independent data auditor who shall evaluate the compliance of the significant data fiduciary. So, all the systems, processes and the compliance with the legislation will be reviewed by the independent data auditor in relation to the data fiduciary, and the data fiduciary also on a periodical basis will have to take a data protection impact assessment to ensure that there would be no breach of data or causing any significant harm to the individuals and public. So, any company that becomes or gets notified as a significant data fiduciary will have more obligations to meet than the regular data fiduciary. The personal data can also be transferred outside the country, but the legislation will come and notify to which countries these data can be transferred by the data fiduciary, and only with according to those conditions can the data be transferred out. And also the requirements imposed or the restrictions imposed in terms of the consent of the data principal, and for transfer of outside the data there are certain exceptions and that have been carved out. It is in relation to if the data principal is not within the territory of India, or it is for enforcing any legal right or claim, or in relation to any of the order or a court, or in relation to any investigation, prosecution and other thing, the government may carve out exception that one, there is no consent required from data principal to process the data, and second, the data can be transferred outside India. There are certain special provisions in relation to data fiduciary having regard to the volume and the nature of the personal data that is processed. The central government can notify any data fiduciary or class of data fiduciaries to whom the provisions of this act shall not be applicable. Given by what we have seen in other legislation, there could be many government institutions and organizations which would be processing massive amount of individual personal data. So, the government may come out with an exception saying that for these institutions who are data fiduciaries by the way, but the provisions of this act shall not be applicable. The government can also carve out exceptions in relation to data retention by the data fiduciaries. They could in the matters of public interest and security and other needs of the state, the central government can say that the data can be retained for longer purposes than what the data fiduciary can do, for specifically in relation to matters of the state. We come to the end of the fourth module. In the next module on the compliance framework, we will discuss on the Data Protection Board and the power that it carries.